Good morning. My name is Susan Singleton from Singleton Solicitors. I specialise in European law, and this short video is about the new Vertical Agreements Block Exemption. The date it's in force is from the 1st of June 2010. It affects distribution contracts which apply in the European Union, so everyone within the 27 EU member states should ensure that their distribution agreements and their distribution practices comply with the new regulation. It replaces the previous Vertical Agreements Block Exemption, which has applied for the last 10 years. So in some senses, it's the biggest legislative change we've had to distribution contracts since that time. The sorts of contracts it applies to include distribution agreements, franchising agreements, and any what is known as a vertical agreement, which means agreements between people at different levels of the supply chain. I've been practicing competition law for a number of years since I was at Slaughter & May, which is a UK law firm, and one of the most common areas of questioning from clients relates to distribution practices. Now, you will either have written distribution agreements, which may need to be revised in the light of the new block exemption, or else you may simply need advice on your selling practices, which is the even more interesting part of this. Let's go back to a few first principles. Under Article 101 of what's called the TFEU, this is European competition law, you must avoid anti-competitive agreements. Now, distribution agreements are full of anti-competitive restrictions, and they always have been. We've had a block exemption of this kind since 1967. So, the European Commission, knowing that agreements of this kind are chock-a-block with anti-competitive restrictions, they've come up with a set of rules, and they've replaced them regularly since 1967, on what types of restrictions are prohibited and which are allowed. So let's get down to some basics. It has always been prohibited to price fix. You cannot tell your distributor the price they will resell at, anywhere in Europe, ever. Take competition law advice if you have any doubt about whether a practice is price fixing. In the UK, for horizontal price fixing, you can go to prison. And companies can be fined throughout the EU up to 10% of worldwide group turnover. So this is not something to save money on and not speak to lawyers. It's a core, important area. If you want to avoid going to prison and 10% of turnover fines, then you should take some advice. So what's changed? It remains prohibited to engage in price fixing. That hasn't changed. The main change is in relation to internet selling, and this is the interesting bit. It's always been a principle of European competition law that you cannot carve up markets. You may have exclusive distribution agreements. You can have your exclusive French distributor, German, Greece. However, you cannot have an absolute ban on their selling outside their territory. So you can say they won't actively market outside France, but they will not have an absolute ban on selling outside there. So draft the contract carefully. Most precedents already take account of that. Internet selling has made this so interesting, particularly for people like me who do a lot of intellectual property rights work, copyright, trademarks, etc. Because prima facie, export or import without permission from an IP rights owner is a breach of the IP right, unless within the EU those goods have been put on the market by the owner of the rights or with their permission. Exhaustion of rights. So, next question, what's changed? I will get to this. Well, internet selling has made it interesting. If you put goods on a website in the UK, are you actively selling outside your territory? Well, a previous block exemption 10 years ago said that that was not active selling, and that remains the case. It also said distributors should usually be allowed to have websites. So the starting point hasn't changed. Let your distributor have a website unless you can justify it. There may be safety reasons. I'm good at coming up with good legitimate reasons why you might prohibit internet selling, but take advice. So other changes, they're nuances really, and the nuances are important. The new guidelines go into more detail on what form of internet restrictions could be prohibited. And let me read them out because I haven't memorised them. So if you agree that you will prevent customers located in another territory from, let's just wind this down a little bit, to view its website or put on its website automatic rerouting of customers to the manufacturers or other distributors' websites. However, you can agree that the distributor's website, in addition, offers a number of links to websites of other distributors or of the supplier. Now, what else are you not allowed to do? You mustn't agree that the exclusive distributor will terminate customers' transactions on a website once their credit card details show that they're not from that country. So you've got a French distributor, someone's ordering in France because they found it's cheaper than in the UK. You can't suddenly stop the transaction because you've realised, aha, they are not French, they are British. You can't stop the transaction, you have to let them go ahead. Third, you're not allowed to agree that the distributor will limit its proportion of sales made over the internet. So you might have, for example, have a selective distribution network. I do lots of advice on this. Only certain people who meet your criteria can sell your goods, and that's allowed. Take competition advice, but it is allowed. So you must not, however, restrict the proportion of their sales. So what happens if they come up with a so-called shop and they haven't really got a proper shop and most of their sales, 99%, are over the internet? You may still be able to stop them, because it goes on to say that this does not exclude the supplier requiring, without limiting the online sales of the distributor, that the distributor sells at least a certain absolute amount in value or volume of the products offline to ensure an efficient operation of its bricks and mortar shop. And also, this does not stop the supplier from making sure the online activity remains consistent with the distribution model. There's more about that in the guidelines. And this absolute requirement or amount of required offline sales can be the same for all buyers or determined individually on the basis of objective criteria. And then finally, you are not allowed to agree that the distributor will pay a higher price for products intended to be resold by the distributor online than for products intended to be resold offline. Very important. Quite a lot of companies do that at the moment. The OFT's looked at it in relation to Yamaha and Sony in the UK under UK competition already. Companies want to support the shops. People go out on Saturday, they look for goods, they spend ages with the salesman, say thank you very much, and they go home and order online. In a way, it's not fair on the shops. So therefore, suppliers want to make sure the prices are higher to the internet sellers than the shops. Can you do that? No, this says. This does not exclude the supplier agreeing with the buyer a fixed fee, it says, i.e. not a variable fee, where the sum increases with the realised offline turnover, etc. So it's a very interesting new regulation. Take advice on it. I am giving a half-day course in London on the 5th of October 2010 on this regulation, amongst other changes, including the Bribery Act 2010 as well. My contact details are on the website www.singlelaw.com, and I also give various other public courses on this area of the law, and of course provide legal advice if anyone needs it. Thank you very much for listening.